You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 90. Knowing your patent examiner can help you. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com, or call me at 424-281-0162. In this episode, I'm talking about how knowing your patent examiner can help you. What I'm not talking about is knowing your patent examiner on a personal basis and making friends with your examiner so your examiner will give your application an easier time and just issue your patent. I'm talking about knowing the statistics about your examiner and how that can help guide you approach your application and how you should respond to rejections. Now, there are really two stages of this. One stage is about how to write your application in a way to get a favorable, easy examiner and avoid a tough examiner. And the second stage is, once you get your examiner, how you should approach any rejections. Why does this even matter? In theory, getting a patent should be objective. Either your invention is new, useful, and non-obvious, and you get a patent, or it's not, and you don't get a patent. But in the real world, there's lots of variability of patent examiners. Some just allow more patents than others. But you can't just write in your application, I want John Smith to examine my patent application. The way that it works is that when you file a patent application, it gets sent to what's called an art group. So your patent application is sent to a place that examines those particular types of inventions. And it just happens to be that some art groups tend to have a higher allowance rate than other art groups. So when you write your patent application, you write it in a way that places it in an art group that on average has a higher allowance rate. Now, I'm not saying it's going to be allowed, but if I told you that this pile of applications will have a 25% chance of allowance based on its history, and this pile of patent applications will have a 75% chance of allowance based on history, which pile do you want your patent application to go into? You want the 75% allowance rate pile. Now, that pile of applications isn't going to go to one examiner, but since you don't know what examiner is going to get your application, then all things being equal, you'd want your application to go in the 75% allowance rate pile. So the question you might be asking is, if my invention is just my invention, why would it be placed in different art groups? Inventions can actually be characterized in a lot of different ways. I'm going to steal an example given by another podcast called Better Patents Now, and that podcast focuses solely on how to play the game of getting your patent allowed by using statistics. And there's a product that they sell that helps you best play these statistics called Patent Advisor. The example they give is a vacuum cleaner. You could say that your invention is a vacuum cleaner. You could claim it's a dust collection mechanism, or you can claim it's a brush. These would all go to different places in the patent office. Now, maybe vacuum cleaners on average get a 50% allowance rate in that art group. I'm just making that number up. I don't know the actual numbers. Maybe brushes get a 60% allowance rate in that art group. And maybe dust collection mechanisms get a 75% chance allowance rate on average. Now, what I mean by allowance rate is that if you combined all of the examiners in that group that examines those things, what percent of those applications actually turn into patents? So the trick in getting your patent into an art group is to focus on words in your description and words in your claims that will bias it going into one group versus another. Now, if you don't want it going into the vacuum cleaner art group because it has a lower allowance rate, maybe you don't use the word vacuum cleaner so much. Use the phrase dust collection mechanism. In your claims, maybe don't say, I claim a vacuum cleaner having parts A, B, and C. Say, I claim a dust collection mechanism comprising parts A, B, and C. There's a product out there, and I'm not endorsing it or not endorsing it. It's called Patent Advisor, and part of what it does is that it uses software to look at your application before you file it and tells you the chances of going into one art group over another. And then you can tweak your application if you want to favor it going into one group over another. There are certain art groups that are notorious for having a really low allowance rate, business methods for one, so you want to avoid a business method art group. So if you have software that does lots of things, but it's really about a method of doing business, you might not want to have phrases that actually say method of business. You might want to say a client-server system, if that's related to what your invention's about. And that could be really helpful in how you draft your application. So that's the first step of increasing your odds, drafting your application to get it to a place called an art unit where on average more patents are granted. Now, once it's in an art unit, you don't have any say on which examiner you get. Maybe you got into an art unit where there's a 50% chance of allowance, but you got really unlucky and you got an examiner that only allows 20% of applications. Well, that's just the luck of the draw. Maybe the reverse happens. Maybe you got into an art unit that only has a 25% chance of allowance, but you just happen to get lucky and got an examiner that has an 80% chance of allowance rate. It's just luck at that point. So how do you know the allowance rate of art units and examiners? There's a free website I use, but there are also paid ones. As I mentioned, Better Patents Now. It's a podcast about playing these statistical games and their products, Patent Advisor. There's another one called bigpatentdata.com that will give you some information for free. You can pay a little bit more. There's one that I use called Examiner Ninja, and the website's examiner.ninja. It's really the first thing that you should do when you get a rejection. And I'm not going to give you a particular name to look up, but if you just want an example, type in Smith, and I'm sure there are lots of examiners with the last name Smith, and just pick one of them, or type in the name of the examiner that you got, and just look at the data that's up there for that examiner. Maybe this examiner has a 50% chance allowance rate, and you got rejected. Now, what can you do to get it allowed? Remember that when you get a rejection, there are all kinds of strategies. Maybe you argue for allowance, and you don't change anything in your application. Maybe you change your claims. Maybe you conduct a patent examiner interview. If you got a final rejection, you could file a request for continued examination, or maybe you file an appeal. All sorts of different things. Now, one thing you might want to do before you choose one of these things is look at the statistics. Now, there's a statistic on there about allowance after an interview, and you can compare it to the examiner's allowance rate without an interview. Now, maybe this examiner has a 90% allowance rate if there's been an interview, and only a 40% chance allowance rate when there isn't an interview. Well, guess what you should probably do? Schedule an interview with the examiner, since that examiner seems really conducive to allowing patents if you actually talk to him or her, and the examiner might give you some pointers on what you need to change in your application to get an allowance. Maybe another examiner has a 60% chance of allowance rate without an interview and a 62% allowance rate with an interview. In this case, it doesn't hurt to have an interview, but don't get your hopes up because it doesn't seem like having an interview helps that much. Maybe this examiner is just wrong a lot of the time, and her allowance rate is 30%, but you see that if you appeal the rejection to the Patent Trial and Appeal Board, the PTAB, the patent gets allowed 90% of the time. So this examiner gets overturned a lot. So if you're deciding whether to argue the claims and file a request for continuing examination with your same examiner, or file an appeal so that it'll go to some other panel and not this examiner, you might want to think about filing an appeal. Now, there's no single answer on what to do, but having a little bit of extra information about your examiner could be useful in trying to figure out the next steps if you're kind of on the fence about what strategy to pick when you get a rejection. There's all kinds of other information that you could look up to get you past rejections. You can look at how other people responded to rejections and what arguments they used to convince an examiner to allow some other applications, and see if their rationale applies in your case, and then maybe you can make similar arguments. Every invention is going to be different, and sometimes there's nothing you can do to get your invention patented. If you're adamant about patenting a bouncing ball with polka dots because no one has ever put 68 polka dots on a bouncing ball and you think you should get a patent for the specific number of polka dots on a ball, I don't care which examiner you're going to get, you're not going to get it allowed. But for the most part, there's a whole lot of gray zone for what's patentable and not patentable, and you just want to give yourself the best chance of allowance. And using data to understand your examiner and the statistical history of your examiner is one way that you could use for your advantage. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your application, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.